Good morning, all. This hearing is in the matter of CFI 079-2023 and is being held by way of video conferencing before His Excellency Justice Rene, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by White and Case. Lead counsel is Mr. Ravi Jackson. The first defendant is represented by Habib Mullah, and lead counsel is Mr. Stephen Docherty. Thank you, Your Honour.
All right, thank you, and good morning to you all. Mr. Jackson, I think we might go to you first. Has there been any further discussion and resolution since the skeletons I received?
No, Your Honour, not between the parties.
Right.
I think there is a fair amount of common ground, judging from my learned friend's skeleton, though, at least on the main issue for directions, which is directions in relation to the claimant's claim for an account.
Yeah.
In terms of the running order, I'm in Your Honour's hands, but it may be sensible to start with that and then work our way through the other three issues.
Yes.
The other three that I've identified, as you will have seen, the other requests that were adjourned, the issue of the costs of the claimant's document production application, and then any directions required as a result of the court's order and jurisdiction.
Yes.
But if we start then with the directions in relation to the claim for an account. As Your Honour will have seen from the skeletons, following Your Honour's helpful indication at the last hearing, the parties are agreed that the process of taking an account should occur after the main trial listed in September. So what we now envisage, in line with Your Honour's provisional view expressed at the last hearing, is a two-stage process, which is that at the main trial, the court will determine issues of liability and whether to order an account. And then if the court does order an account at stage 2, the account will be taken. So if Your Honour's content to proceed in that way, the question then is, well, what directions are required to give effect to that stage 2 process? And if I can deal with the stage 1 directions first.
Yes.
The stage 1 directions, as we understand it, are agreed between the parties. And it may be helpful if we pick this up by reference to the current ordered directions. So if Your Honour has the bundle from the last hearing, which I think we're using for this hearing as well.
All right, let me see if I can find it. Yes, I have it. Hopefully it'll open.
Yes, and if Your Honour would turn to page 1124 of that.
Yes.
So in paragraph 4 of this consent order, that sets out the current procedural timetable, leaving out directions of skeletons in the trial.
I said yes, but I'm afraid it's just showing me a circle at the moment. Oh, yes. Now, wait a minute. No, that doesn't seem to be right. I've got a direction. I've got a bundle for today's date. Was that?
Yes, I think what happened with the bundle is that the last bundle from the previous hearing was just updated in minor respects.
All right. So shall I go back to the previous one?
Yes, if that's convenient, Your Honour. I mean, there shouldn't be any real changes between them.
Might be different page numbers or something. So
Perhaps.
I want the one from 14th of April. See if we get that one. Okay, we'll try again. Yes, all right. Now what paragraph number?
So it's page number 1124 and paragraph
Yes.
4 of the consent order.
Yes.
And that sets out the current procedural timetable leading up to the trial.
Yes.
Now, the parties have agreed to extend the deadline for document production, which isn't shown in the consent order. They've agreed to extend that until today. Following the previous hearing, the parties had agreed that the time for giving document production by way of the document production statements and production of the documents themselves would be the 13th of May. So it's been agreed that there should be a 1-week extension to that until today.
Yes.
So that is the starting point. We then obviously have witness statements. In my learned friend's skeleton argument, it suggested the deadline for those should be pushed back by a week, consequential upon the deadline being extended for document production. And for our part, we're content with that.
Yes.
That would mean main witness statements would be due on the 20th of June and reply witness statements on the 4th of July.
So sorry, so it's witness statements by the 20th, reply by the 27th, was it? No.
By the 4th of July.
By the 4th of July. Yes, all right.
There's then the issue of expert evidence. As Your Honour can see, directions have already been given for expert reports on the quantum of an account, but for obvious reasons, that's relevant to stage 2 rather than stage 1. So, so far as the parties are concerned, I think it's agreed that those directions can be dispensed with so far as stage 1 is concerned.
So we should vacate that order.
Yes.
Yes.
And following on from that, we already have directions for this, but just so Your Honour has the full picture, skeleton argument, the trial would then be due on the 15th of September.
Right.
And the trial itself would commence on the 22nd of September.
Yes.
So those are the stage 1 directions. If I can then deal with stage 2, there is a slight difference of approach between the parties on what the court should order by way of directions for stage 2. The claimant's position is that the court should direct a provisional timetable for stage 2 now, with that timetable being contingent upon the outcome of stage 1. Whereas the first defendant's position, as we understand it, is that the court should list a directions hearing following stage 1 to consider the question of directions for stage 2.
Yes.
So that, I think, is the only real difference between us. Your Honour, there are 3 reasons why we say the court should direct a provisional timetable for stage 2 now. The first reason is that there has already been, it's fair to say, a significant amount of delay in the proceedings. And it's therefore important, we say, that if we get to stage 2, the accounting process is conducted as efficiently as possible. As Your Honour knows, these proceedings were commenced in October 2023, so around a year and a half ago. By the time of the main trial, it would have been almost 2 years, and by the time of judgment, likely over 2 years. And with that in mind, we say that the directions should seek to minimise any further delay to the final resolution of the proceedings. The second reason is that we say having a provisional timetable, albeit subject to further consideration following stage 1, is likely to be the best way to ensure that the stage 2 process is efficient. Because on the first defendant's proposal, the parties would need to consider directions afresh following stage 1, and may indeed need to come back to court for a hearing on that issue. Whereas by setting a provisional timetable now, that is likely to be avoided. If the court orders an account at stage 1, then the parties can simply proceed with the stage 2 timetable. And obviously, if the parties need liberty to apply to come back for any additional directions, they could have it. but setting in place at least a provisional timetable seems to us to be a sensible way to proceed. And the third reason why we say there should be a provisional timetable is that there's no practical difficulty in ordering one. And just to explain what a timetable would look like, as Mr. Doherty notes in his skeleton argument, the usual process for an account under the DIFC court procedure is that the accounting party will first file an affidavit exhibiting the account. And following that, the other party will serve written notice of its objections to the account. So in essence, what we propose is that the court directs that insofar as an account is ordered in the main trial, and that could be an account that the claimants are entitled to or that the first defendant is entitled to, the accounting party will then file an affidavit and the opposing party will serve written notice of any objections that it has. And the parties can obviously discuss dates, but we suggest that could be done in a relatively short timescale following the order from the main trial.
That immediately introduces a practical problem, and not just a problem, but also shows, I think, why for the moment I can't see that anything is gained by doing that. It must, of course, await the court's decision, being, first of all, whether there should be an account. Of course, if the court was to dismiss both the claimants and the defendants' claims for an account, then that's the end of that issue. If the court does order an account by one or other of the parties, then, as you've said, the first step or steps are first to order that the accounting party file their account verified by affidavit. Well, I pause. I should draw that. The usual process is for the accounting party to file their account verified by affidavit. Now, obviously, the date for that to happen all depends upon when the court delivers judgment. And for the moment, I can't see any possible benefit in fixing a date now. I, of course, can't tell you when judgment will be delivered. We can all take a guess at it, and presumably the date by which the accounting party would be ordered to file their account verified by affidavit would be a certain number of days after the guessed date of delivery of judgment. Now, if, on the other hand, that is not ordered now, then soon after the delivery of judgment, we'll all either convene or agree that by a certain date the accounting party or parties will file their accounts verified by affidavit. So on the one hand, I can't see how we'd specify a date for filing the account other than being so many days after the delivery of judgment. On the other, to actually await the judgment and then order it be so many days achieves exactly the same result. So can you tell me what I'm missing on that, Mr. Jackson?
So if I can deal with how one might specify it, the way one would specify it, Your Honour, is to say that it first of all, it's conditional upon the court ordering an account, because that's obviously a requisite. And then, as Your Honour says, it would have to be so many days after the court directs that an account should be taken. That would be the way one would specify it. We do say that is likely to be more efficient then reconvening for directions following the court ordering an account. Obviously, if the court doesn't order an account, then the directions, if they're framed in a conditional way, simply don't have any effect, or rather, there's nothing for the parties to do because the court hasn't ordered an account. So practically, there's no reason it can't be done. What we say is that it's likely to produce a more efficient stage 2, because the parties can then just proceed with directions rather than having to reconvene or discuss directions between themselves. But obviously, if your honour's not minded to take that course, the alternative would be that we have some form of directions hearing following the court's order in the main trial. But what we would suggest in that scenario is that if I can respectfully suggest that the court make clear to the parties that that's to be listed in short order following the court's order.
Yes and no, Mr. Jackson. The yes is that I would intend that it would come on as soon as is both practical and efficient, and the no is to do with the second part, the efficiency of it. The directions which will be given or would be given for the taking of the account might depend or might be affected by what has come out at trial. And by that I mean this. One question, for example, is who takes the account, whether it's me or the registrar. As you know, the rules say, in a sense, the default position is the registrar, but I rather think this is a more complicated case than the usual taking of an account, and probably would be best taken by me rather than by the registrar. The second aspect then is what form the account should take, and that is, in the first instance, the accounting party is to file their account, and together with, I forget how it's put in the rules, but the usual way is that it's supported by books, invoices, and so on. Now, it might be that there would be some benefit in tailoring that order, and how that's to be done might be informed by the evidence at trial. May not, but I think there is a reasonable prospect that the evidence may better inform what documents should support it. So, for example, where the claim, I think the account sought is for profits. Now, we might have a better idea after trial what that's going to involve. Is it going to involve accounting for hundreds or thousands of receipts of amounts? Is some different approach to be taken? Now, the evidence at trial may not help with that, but it might. So for that, amongst all the other reasons, I'm against making any orders now. And as to your point about it should be done soon afterwards, yes, that is, the giving of directions for the account should be done as soon as is both practical and efficient after the delivery of judgment. But in the first instance, I would expect the parties to confer and discuss the sort of things I've been talking about. What form the account is going to take, what documents will be lodged with the initial account. I think that in the long run might be more efficient than, for example, a process where the accounting party decides what's to be done. I think the rules, I think Mr. Doherty referred to them in his submissions. Yes. Oh no, verifying, looking to see the rules somewhere referred to the account being accompanied by the records. Oh yes, 36.57. The court may direct that in taking into account the relevant books of account shall be evidence of their content, but that any party may take such objections to the contents as they think fit. Well, there doesn't seem to be anything in the rules about it being accompanied by the original account being accompanied by documents. But again, that might be the sort of thing that might be usefully addressed up front. So, in answer to your question, the yes, Mr. Jackson, is that my intention is that if an account or accounts are ordered, they should be got on with lickety-split. But I also intend that the parties and then the court should give some consideration to tailoring the process to the circumstances of the case. So I hope that helps.
Yes, that's very helpful, Your Honour. I think that deals with directions in relation to the claim for an account. The other three issues, if we take them in turn, the first issue is, or rather the second issue overall, is request 12 to 15 of the claimant's application for document production. And as Your Honour knows, those were adjourned from the last hearing, pending further consideration of whether there should be a one-stage or a two-stage process. I've addressed this issue at paragraphs 8 to 10 of my skeleton. And as set out there, our position is that even though the documents are relevant to stage 2, which is the taking of the account, the court should nonetheless order their production now. And there are two reasons why we say it would be beneficial for the court to do so. The first reason is that, for the reasons I submitted earlier, we say that the court should try and minimise any delay to the final resolution of the proceedings. And that, in my submission, militates in favour of the documents being disclosed now. And just to unpack that, the basis on which both parties proceeded, at least up until the last hearing, was that all document production should take place at stage 1. And there's no reason practically, therefore, why the documents can't be disclosed. If there were, if the court were to postpone document production, the documents may need to be disclosed at a later date. And I've heard what Your Honour has said about it may be beneficial to have further documents at stage 2, but at the moment it isn't clear whether such documents would be ordered. All one does know is that all documents the parties currently consider to be relevant have been addressed in the document production process to date. So there's no reason practically why document production can't be ordered. It's how both parties have proceeded. And if for example, it turns out that there aren't any further documents that one needs to produce for the purposes of stage 2, but these documents need to be produced, we say that would be undesirable, because one would then have a separate but relatively limited phase of document production later. So in short, my submission is that these documents should be provided now on the basis that that constitutes efficient case management. The second reason. Yes, Your Honour. The second reason, leaving that aside, is that the production of these documents is likely to assist the parties in considering settlement. At the moment, the claimants don't have any real information as to the quantum of the account that they seek. And in order to understand that quantum, we need production of these categories of documents. The consequence of not having the documents is that it makes it very difficult for us to meaningfully engage in settlement because the quantum is unclear. So if the documents are disclosed and the quantum is much clearer, that we say is likely to assist the parties in engaging in settlement discussions, and not only for the purposes of seeking to avoid an account ever having to take place, but also for the purposes of seeking to avoid a main trial in September, which will obviously be of significant cost. So for those reasons, Your Honour, we invite you to order that requests 12 to 15 be answered now.
Thank you. Mr. Doherty.
Yes, thank you, Your Honour. I think both the position on directions and document production somewhat strikes of cart leading the horse, in that the reason my learned friend wished to have an efficient procedure was to...
Let me try and cut to the chase a little bit, Mr. Doherty. I was against Mr. Jackson until he mentioned his second reason, the possibility that it might facilitate settlement. I did, up until that point, I was of the view that on case management grounds it was not efficient. But the settlement issue is a different question. Do you want to address that?
Yes.
And any other things you want to say why
yes.
I shouldn't order it?
Well, perhaps I can run through essentially the issues that are put forward by my learned friend and the skeleton, just deal with each of those in turn, and why we say it doesn't really work what's being proposed. So I think the first point made had to do with delay. There's already been a delay in proceedings, that things should proceed as efficiently as possible.
I'm not persuaded by that, Mr. Doherty.
Yes, and of course, respectfully, that's always going to be the approach that the court adopts in trying to manage things as efficiently as possible. But when one looks at the overriding objective, efficiency doesn't mean speed at all costs or speed in relation to one issue. It means, amongst other things, ensuring parties are dealt with in an equal footing. It's about saving expense, and it's about dealing with things with a measure of procedural economy. And we say that the claimant's proposals fall well short of that aspiration. That's, of course, something that Your Honour should take into account in deciding what to direct. Part of what the first defendant is alive to in this proposed approach is what one might view as being a litigation tactic. So one not designed to do justice in relation to the stage one proceedings, but to try and exert pressure. And one can already see that strategy playing out. So I think the point was made by my learned friend in his skeleton that the documents that are sought are limited in the type that are commonly produced. And so it's not going to be onerous to make an order for production now. That is a rather thin submission, we say, because just yesterday the claimant's solicitors sent a letter to the defendant seeking copies of, amongst other things, an additional purchase order. So this is document requests arising from issues that have been dealt with in one of the series of international proceedings taking place in other jurisdictions. There's been a request for, quote, all email correspondence relating to that particular purchase order. There's been a request for any and all other purchase orders entered into by the third defendant with any party. There's been a request for a copy of a contract associated with a particular purchase order. There has been a request for a broad category of information relating to, quote, investments made by the third defendant, And as well as that, details of, quote, sources of funds for those investments. And perhaps most startlingly, there was a request for, quote, all project contracts, employment contracts, purchase orders, copyright registrations, lists of customers, related contract documents, and any contracts entered into by the third defendant, in effect with any company, and specifically Health Insights Egypt. And we say it's pretty easy to see what's going on here. There's a request made before Your Honour this morning for what is framed as a narrow category of documents, which we discussed at the document production hearing, followed up pretty quickly with wide-ranging requests that seek information that has no bearing on the determination of the pleaded cases at stage 1, which at least gives rise to the prospect that what we're dealing with in requests 12 through to 15 is not the end, but rather the beginning of what is going to be a series of, in effect, satellite litigation, satellite applications to deal with document discovery. The idea that there's going to be production of the accounts, and that would lead to a realistic prospect of settlement, as opposed to simply opening the door to further case management issues arising in the case, we say is pretty speculative for other reasons, which I'll come to. But broadly, we say it would be naive to think that the production of requests 12 to 15 now would be the end of it. And the scope for matters expanding far beyond the scopes of requests 12 to 15, and upon receipt of those documents, getting yet more requests for information, all the while the defendants are preparing for the trial of stage 1, alone gives rise, or should alert the court to the requirement to deal with parties on an equal footing. So in effect, the defendants are in the position of having to manage their resources and to manage document production and facilitate a document production process, whilst the claimants are focusing on preparing their witness statements and for trial of stage 1. So the first point is a balance issue and a opening the door to further requests issue. The second point we make has to do with procedural economy. And I suppose this feeds into some of the observations that Your Honour's made already. There's obviously a pretty wide distance between the parties on how they view this case, with the various competing allegations of wrongdoing and who's acting in the interests of the second defendant. And of course, it must follow from that we have a very wide range of permutations of outcome from stage 1. Obviously, we're not in a position to preempt any of that at this point. But when it comes to this question of producing documents which are relevant to a potential account in due course, we say would mean incurring costs in respect of an issue that isn't straightforward, nor is it one that the court is even necessarily going to need to look at depending on the outcome. And what that means is that when one looks at the overriding objective, production of that material now is disproportionate. As I've already said, it doesn't treat the parties on an equal footing. It doesn't save cost and is inconsistent with the overriding objective. And a linked point to that relates to the abortive work that would necessarily or potentially be carried out if the aim of dealing with matters in this way is efficiency, because it isn't only the cost associated with dealing with the production of documents or follow-up requests itself. That, of course, might turn out to be unnecessary in light of the outcome of stage 1. But there's also, of course, the cost that would necessarily go into analysing those documents, potentially instructing experts in advance to undertake work which will bear no relationship or will prove to be abortive, depending on how the trial of stage 1 pans out. And if the outcome of proceedings is that the claimants are to account to the second defendant and the first defendant isn't, any time spent on that will have been wasted cost. Which I think then brings me on to the the final point we make about there being a prospect of settlement, and I think the suggestion being put that there was no material prejudice to the defendants in producing documents. We say that that's not a point which is particularly well taken when one looks at the overall context in which this dispute arises. Of course, as I've said, there's already a very wide gap between the parties in respect of the nature of the allegations that they are making. As Your Honour is aware from other aspects of these proceedings, there's litigation going on in various other jurisdictions. The claimants have already somewhat taken it upon themselves on the defendant's submissions to make allegations in those proceedings which are inconsistent with how they're putting their case before the DIFC court, including on some central issues. For example, which entity owns MCC? Now, one might look and say, well, there's a trial in September and there's no way we're going to be able to compromise that unless we've got the information from a quantum perspective. But that somewhat ignores the broader context and the fact that there are a series of other sets of proceedings ongoing in other jurisdictions. And it's somewhat to assume that the DIFC court proceedings are the only matter in which these issues are being litigated, or for that matter, the only set of proceedings in which there is another entity asserting ownership of Medica Cloud Care. So the first point is that given the broader context and given the existence of these other proceedings, the prospect of the disclosure of narrow categories of financial information being the trigger point for encouraging the parties to settle, we say, is unrealistic. The second point is that the defendants, again, in the context of those other proceedings, have legitimate concerns about collateral use of materials disclosed. And an example of that, we say, one can see in the letter received yesterday, where documents obtained in a separate set of proceedings have been used as a launching pad for a wide-ranging set of requests of documents belonging to the third defendant in the context of these DIFC court proceedings, when they are not relevant to the issues to be determined at stage one. Perhaps more importantly, the first defendant, again, as Your Honour is aware, and as the first defendant has dealt with in his witness evidence, has been personally subjected to a multitude of spurious criminal allegations in other jurisdictions, which have been dismissed, for example, in proceedings in Egypt, but not before putting the first defendant to great trouble and personal hardship. But again, the risk of documents being used to pursue allegations in a criminal forum as a tactic is something that the defendants are quite understandably alive to at this point, and which the first defendant has reason to believe is an ongoing issue. So that includes attempts to seek to impose, amongst other things, travel bans in Dubai in connection with issues that arise in these proceedings. And it's not simply about collateral use, but that sort of context is also relevant to whether or not Your Honour were to view the prospect of these documents being produced as making settlement realistic ahead of a stage one trial in September. And we say that clearly the manner in which these proceedings are being fought on multiple fronts in multiple different types of proceedings, so both civil and criminal, means that that's in itself an outside prospect. And so for those reasons, we say that the overwhelmingly supported approach in this case is, in circumstances where Your Honour is going to set fixed directions for stage two, once the outcome is known, procedural economy would dictate that where information is going to come to light during trial, where the permutations of outcome will be known at the point in time that a directions hearing is fixed, The better course would be to order production of those documents at a time when one can see that it's actually going to be useful or relevant to what's left in the proceedings. So if there is to be an account, there's no reason why, for example, Your Honour wouldn't be able to order that a directions hearing is fixed to deal with the taking of the account, say 2 weeks or 3 weeks, whatever it happens to be after the decision is rendered. And in the meantime, ahead of that directions hearing, the documents at request 12 to 15 could be produced at that juncture. That's a way of dealing with things with procedural economy rather than speed at all cost.
Yes. Thank you. Mr. Jackson, in reply.
Just very briefly, Your Honour, there was a lot in my learned friend submissions that go to what might be called conduct points, which are that we made some requests and they're tactical or oppressive in some way. It's true, we have made requests for documents in correspondence. That, if necessary, will be the subject of a separate application at a separate time, and the court will have to consider that on its merits if it comes before the court. It can't be taken into account in determining whether, at this stage, requests 12 to 15 should be answered. Similarly, my learned friend suggested that there were some concerns about collateral use. That's certainly the first time that that's been raised during a hearing. In terms of collateral use, the principles that apply in the DIFC are very clear. And if the documents are produced at this stage, they will be subject to the usual collateral use restrictions until they're referred to publicly at a hearing. So that doesn't present any difficulty with producing the documents now. Just dealing with two other points, my learned friend suggested that production would be disproportionate and inefficient because the court may not have to look at the issue of an account at all. And of course, the court may not have to, depending on what it rules at stage one in the main trial. But our point is that one may not even need to get to the stage one trial if the documents are provided now. Because if the parties can then meaningfully engage in settlement, it may not be necessary to incur the costs of that trial process. Now, my learned friend's response to that essentially was to say that, well, there's a fairly limited prospect of the parties settling, given that there's litigation ongoing in multiple forums. Now, Your Honour is well experienced. Often disputes are hard fought, and sometimes they do settle. So that isn't an objection to the documents being provided now to assist settlement. Your Honour, that was all I had.
All right. Thank you. I will not order production at this stage. I have 3 or 4 principal reasons. The first reason is that an account may not be ordered, and if an account is not ordered, then the costs incurred in producing these documents would be wasted. Secondly, if an account is ordered, then what documents will need to be produced in the course of the taking of that account will be informed by the form the account takes, the directions which are given, and it will be more efficient to deal with the question of production of documents as a whole, rather than doing it piecemeal and then seeing what overlaps there are and so on. It is more efficient to deal with it in the one go. Thirdly, I am conscious of what the parties have said about preparing for the trial. There are references in one or other outline about the timetable being tight. Whether that's so or not is no reason why all of these steps that have been ordered will not be taken and taken on time. But I'm aware in the lead up to a trial, parties have got a lot of work to do, and to take on the production of documents which are not necessary for the trial is a distraction from getting on with the main job. The fourth point, so for all of those matters, point against the overriding objective being furthered, or objectives being furthered by ordering production at this time. I did give consideration to the matter Mr. Jackson raised about it assisting settlement. Having given that some consideration, I'm not persuaded that the production of these documents would sufficiently increase the prospects of settlement to overcome the matters that I've already addressed. So what I will do in relation to this outstanding part of the application is to adjourn the application until adjourn it pending the trial, that is to come on after the, pending judgment following the trial, and the costs will be reserved. All right, what's the next issue?
Your Honour, just so I understand your ruling, did Your Honour have in mind that the costs of the claimant's document production be reserved, or just the costs of requests 12 to 15?
Well, just I only addressed my mind to request 12 to 15.
Yes, because there is the balance of the claimant's application.
Yes.
And I've dealt with this in my skeleton. But essentially, what we say is that even leaving aside requests 12 to 15, the claimants have substantially succeeded on their document production application, and costs should follow the event in the usual way. And perhaps I can just take Your Honour through why we say that.
Briefly.
Yes. If Your Honour would go to the bundle.
You know how much judges love arguments about costs.
Yes, quite, Your Honour. Well, I will be brief on it. There aren't many points to go through. If Your Honour would go to the bundle, and it's at page 205. This is Ms. Roshan's fourth witness statement, which was filed in support of our application. And I go to it just to remind Your Honour briefly of the requests, or the other requests that we dealt with at the last hearing. So if Your Honour's at page 205,
yes,
you'll see request 3 there, which was we sought additional documents which are specified in paragraph 12 of Ms. Roshan's statement. We succeeded on that. The first defendant resisted those additional documents. Pardon me, it's actually the documents at paragraph at paragraph 13 rather than 12. The first defendant resisted those documents being provided. Your Honour ordered that they should be provided. So we succeeded on that request. Over the page, Your Honour, at paragraph 18, we had requests 4 to 7. And the dispute there was whether the date range should be 1 month or 3 months around the date of execution of various purported agreements. The claimants succeeded on that date range. And then again over the page, if we go to page 208, Your Honour will see request 10, which was essentially for documents relating to D2 and its auditors. Your Honour can see the specific wording at paragraph 25. So essentially audit documentation. And over the page, on page 209, there's request 11, which fell into a similar camp, said that it was essentially banking documentation relating to D2. And we succeeded on both of those with a slight amendment to request 11 to exclude documents relating to HSBC, which were already within our possession as we accepted at the hearing. So on all of the requests, save for request 12 to 15, which Your Honour has adjourned for a further decision, we succeeded with only a minor amendment to request 11. So for those reasons, we say the cost should follow the event.
How would the assessment of the costs be undertaken if the costs of part of the application have been reserved?
Well, one could do it one of two ways, Your Honour. The first way would be on the basis that the request 12 to 15, because they've been postponed to a later date, need to be carved out. But that the reason why Your Honour has adjourned requests 12 to 15 is not an argument that was raised by the first defendant at the initial hearing of the document production application. So while in principle one sort of might carve those off, we say it hasn't caused any additional costs to be incurred so far as the document production application was concerned, because this was a point helpfully raised by Your Honour as to whether there should be a two-stage process. So it's unlikely to affect the actual costs of our application. But if it did, then one would have to make some form of apportionment. And that might be best reflected in a percentage-based order that Your Honour would make on costs, obviously to avoid the need to sort of go through line by line and apportion to different requests which arose in the application. If Your Honour was minded to make a percentage-based order, in my submission it should be a fairly limited one, given that the real argument about these requests concern the one-stage versus two-stage process, rather than the actual objections that were raised by the first defendant.
All right, thank you. Mr. Doherty?
Yeah, sure. I think, yes, the broader point is that, and you might recall the cost submissions I made to you at the last hearing.
Afraid I don't.
Well, I'll remind you, one, to form the view the claimant should be entitled to any costs at the last hearing would require one to divorce themselves entirely from the context in which the document production
submissions
hearing came about. I suppose just very briefly, Your Honour might recall at the beginning of the cost assessment in the last hearing, you'd expressed a provisional view that it should be costs in the case. I then spent some time taking Your Honour through some of what we say were the conduct issues that prevented any meaningful cooperation or engagement with requests being rendered impossible effectively, and that led to awarding the first defendant its costs of its document production application. The broader points arising from that were, first, that the majority of the time and cost incurred in preparing for the document production hearing as a whole related to the claimant's ongoing resistance to what was the first defendant's successful application for an order. I think my learned friend used the term at the outset of the last hearing that the meaty part of the dispute was in relation to the claimant's objections, and that's what consumed a lot of the Oxygen submissions preparation time.
All right, and just a minute there, Mr. Docking. If that's so, wouldn't that be reflected in the assessment of the costs? That is, I've awarded you the costs of your application. If I awarded the claimants the cost of their application, in the assessment, wouldn't you get more than them because your application was the expression, the meaty one?
That is correct, but again, if one ignores the context in which the application came about and the requirements of the rules. So the entire way that Part 28 is structured is designed to encourage cooperation. Now, cooperation can't be a one-sided thing. There has to be a meaningful dialogue about document production requests, and where you've got one side who's willing to enter into some form of discussion and try and narrow down some of the issues, where you have one party who's entirely resistant to that, it makes meaningful cooperation impossible. And to give you context on how, first of all, the request to reduce panned out, the first defendant made 17 requests. 13 were rejected completely. 4 were notionally agreed, but Your Honour will recall having to make orders about those requests in any event because no documents were produced, or not all documents were produced that responded to them. So ultimately what that led to was most of what was being sought being granted to the first defendant at the hearing. By contrast, of the 19 requests to produce made by claimants, 10 were either agreed to or offers were made in the Redfern schedule effectively to produce subject to offering a narrower scope or offering narrower date ranges. So at that point, there was an attempt to narrow the issues where possible, where there was resistance to some requests on the basis that they were overly broad. The objections stated that. And again, had there been meaningful cooperation, there might have been a way to cut through some of those issues. But ultimately, what happened was after the requests to produce were exchanged, the first defendant proceeded in January to make an application for a document production order in light of the wholesale resistance to disclosure. The claimants didn't make their application until the middle of March. So it was somewhat of an afterthought. There was no attempt to meaningfully engage. And by the time the application was made in March, some efforts had been made by the claimant to narrow the scope of their own requests, but that was only at a time when it was clear, first of all, that there was already going to need to be a contested hearing to deal with the first defendant's request to produce. So, like I say, the meaty part of the costs were already about to be incurred. But if one then looks at the state of play, so for example, when one looks at Roshan 4 and the nature of the request and the nature of what was disputed, really it was minor points around the edges. So it was about agreeing date ranges, or it would have been about minor disputes, which we say could have been resolved if it had been in the context of some broader cooperation by the parties, not only in us simply acceding to the claimant's request and what they wanted, but them also dropping points that they really shouldn't have been taking the contested application anyway. And Your Honour will recall the points that were taken by the claimants in opposition to the first defendant about possession, custody and control and so on, some of which weren't even advanced by the time we got to the hearing. And had those points been dropped earlier, and you can enter into meaningful dialogue as to reasonable parties seeking to cooperate, the issues dealt with in respect of requests 3, requests 4 to 7. So 4 to 7 was simply, should it be 1 month or 3 months? It's very difficult to see that that would have ended up going to a contested application if there hadn't been other more hotly contested issues already in play. And similarly, requests 10 and 11. Really, the only requests where there was, I suppose, a fundamental dispute between the parties was in respect of requests 12 to 15. Those weren't extensively broad issues. They didn't occupy a lot of hearing time, but those were issues which probably wouldn't have been narrowed had we come to a hearing. But it's difficult to see in my submission how there could not have been meaningful cooperation on the narrower points of dispute on other issues. And that's a long way of saying that the hearing on those requests could have been avoided with earlier and meaningful cooperation on the part of the claimant, rather than them belatedly narrowing the scope of their requests, having filed an application 2 months later than the defendants did, and at a point in time that a hearing was already looking like an inevitability.
Or I think
and so on that basis, we would suggest that it's in respect of the requests that have been granted, that's a cost in the case, and the costs probably ought to be reserved in respect of 12 to 15 on the basis that those were the more genuinely contested aspects of the claimant's application.
All right, thank you. Mr. Jackson, in reply.
Just briefly, Your Honour. In my learned friend submissions, there's a real blurring of the two applications together, including in relation to the procedural history of them. What the thrust of his submissions seem to suggest that the first defendant would have consented to our application if there had been more cooperation between the parties in respect of the first defendant's application. What the court needs to look at is, well, what was the procedural history of this application? Was there any reason for the first defendant not to consent to the request on which the claimants have prevailed? And in my submission, it's simply not correct when one looks at the procedural history to our application to suggest that there was no meaningful engagement or no meaningful dialogue. If I could just briefly take Your Honour to a letter that we send, which is at page 232 of the bundle.
Yes.
So this is a letter dated, as Your Honour can see, the 12th of February 2025. So it's approximately 1 month before we issued our application on the 13th of March. And I won't go through it all, Your Honour, but in short, this letter set out almost identically what we were seeking, or what we ended up seeking by way of the application on which we succeeded. And there, if Your Honour looks, for example, at request 3 on page 223, Your Honour can see at subparagraph C, those are the additional documents that we seek. Over the page on 234, Your Honour has request 4, where we set out our proposals on the date range, and that continues for the next 3 requests as well. And then if Your Honour goes to page 237, Your Honour can see requests 9 and 10, and at page 239, requests 12 to 15 are dealt with there. So we did attempt to engage with the first defendant on what became our application, and what we put forward, and the relief that we ultimately succeeded on, say for in requests 12 to 15, wasn't consented to, and for that reason it was necessary for us to issue the application, and we've succeeded on the application. In those circumstances, the starting point should be, in my submission, the costs do follow the event. One can't blur the applications together, and there's no reason in terms of the procedural history of the claimant's application as to why we should be deprived of those costs.
Yes, I think the starting point is that the claimant was largely successful in the application and should have the costs of the application. I take into account the matters that Mr. Doherty has referred to, but in my view, they are not sufficient to displace the general rule. A difficulty is that the court has not addressed request 12 to 15. I have already indicated that I will adjourn the application insofar as it relates to request 12 to 15. The possible orders that I could make are to simply adjourn the question of costs pending the outcome. But I think that the more just and efficient outcome is to give the claimant part of its costs. At this stage, I will direct that the claimant should have 3/4 of its costs of the application, and the costs in relation to request 12 to 15 will be adjourned. All right, what's next on the agenda?
Thank you, Your Honour. The only other point, or the only other issue, is whether any directions are required as a result of the order that Your Honour made dismissing the third defendant's jurisdiction application For my part, I've addressed this at paragraphs 12 to 13 in my skeleton argument. We say it's difficult to see what directions would be required because the third defendant has been joined principally to the proceedings because its rights would be affected by the orders sought by the claimants at trial. But given that it's wholly owned and controlled by the first defendant, it seems very likely, at least to us, that it will simply adopt his position. But I'm obviously not acting for the third defendant. And so far as we're aware, no proposals have been made so far by the third defendant as to what directions, if any, it seeks. I note that my learned friend's skeleton is headed D1's note for the hearing. I don't know whether he is acting for the third defendant for the purposes of this hearing.
Yes, indeed, Mr. Doherty, I'm remiss in either forgetting, not paying attention to, or not interrogating who you're actually appearing for on this application.
Sorry, I think it's the. Of course, I've appeared for the third defendant before in other contexts. It's I think that was my probably copying a very head note from another CMC. When it comes to the actual issue,
well, no, just coming back.
Oh, sorry. Yes.
Does that mean you're appearing for all three defendants today?
For the first and third.
First and third, yes. All right.
And when it comes to consequential directions, I think myself and Mr. Jackson are probably on the same page. The nature of the third defendant's involvement is it is joined as a party as a consequence of the order directly affecting it, rather than it being a case of specific relief being sought from the third defendant. And in any event, the alignment of the first defendant and the third defendant's position is such that it's difficult to see that there would need to be consequential amendments to pleadings, for example, or any other issues that won't be picked up in witness evidence.
What defence has been filed? Just a defence of the first defendant? Well, the third defendant hasn't filed a defence, has it?
No, it won't have, because there were obviously jurisdictional issues involved at that point in time.
Well, should it file a defence even if it's to say that it abides the outcome or adopts the first defendants, or is it going
for the sake of order?
At the moment, you may not know this, but do you have instructions to appear for the third defendant at trial?
I don't have instructions currently on that basis, but one can anticipate. But I can take instructions on that issue. But if Your Honour wished to put in a direction to the effect that the third defendant should either file a defence or file some form of document which acknowledges that it adopts the position of the pleaded defence of the first defendant.
Yes. Or, well, I say, I think three options at least occur to me, and there may be others, but one is to file a defence putting its position. Another is to adopt the defence of the first defendant, or a third one is simply to abide the outcome of the trial. There may be other options, but it would be wise that the third defendant discloses what its position, so that it's not like an Agatha Christie at the trial where I'm wondering where the third defendant is going to appear and whatever.
I would have no objection to that course.
All right. How long do you think? 2 weeks?
Yes, that'd be fine.
Your Honour, just so
yes,
apologies, just so I can be clear on the procedure.
Yeah.
Because there's going to have to be an order drawn up, I think, giving that direction. I think it would be sensible.
And Mr. Jackson, I'm going to ask you to draw up a minute.
Yes, quite. I was thinking of myself saying this.
Yes, very wise.
Yes. It would be sensible in my submission for the court to elect between one of those three options which were just canvassed, so everyone knows where they stand. It seems to me...
I had in mind that the order B, the direction B, that the third defendant file a defence or a notice abiding the outcome of the case. So I think that covers the options, because the defence it can file can simply adopt the first defendant's defence. I would accept that as being a proper or a reasonable defence. Or are you suggesting that I should make an order which gives them three options? One, file a defence; two, state that they adopt the first defendant's defence; or three, abide the case. I'm not so sure about a notice that they adopt the first defendant's defence. I'm not sure I can recall seeing that after the event. Would it be dealt with if the order is simply that the third defendant file a defence or a notice that it abides the outcome of the case? That would be sufficient, I think, would it not?
Well, the notice that it abides the outcome of the case, I'm not sure that would be necessary, Your Honour, because the third defendant is subject to the court's jurisdiction in light of your order, and it's a party to the proceedings. I think it would be more conceptually clear if it was required to file a defence. Now, the first and third defendant may want to do that by way of some form of simply just a copy and paste job, if I might call it that, from the first defendant's defence, so that effectively one has one identical pleading but filed by two parties.
Mr. Doherty? I come back to you because in one sense I want to avoid unnecessary cost and complication.
If it was adoption of a defence, I suppose one could see it in a way where if you had an application for joinder which was supported by, say, draft amended particulars of claim, which included in red line and the third defendant, one could probably do something similar with the defence, where you red line defence of the first defendant and you just go through and make sure that the references would track across to be clear that they involve the third defendant. So that might be one way to deal with it as well, almost to treat it as if it's an amended defence on that basis.
Yes, I think
it'll be subject to instruction, but that might be a neat way of doing it, so that one works off, in effect, one document.
That would be, yes, I think that would be helpful. As you say, if we end up with one document we can all work from. So the order then for Mr. Jackson to draw up would be the defendants have leave to file an amended defence within 14 days. I won't attempt to put it into the order, but as I say, between us, if it can be understood that that is simply for the purpose of bringing the third defendant in, and any substantive amendments would give rise to some strikeout, I think.
Yes, thank you, Your Honour.
All right, so what's left?
Nothing as far as we're concerned, Your Honour.
Sir Doherty? All right, well, so far as you're both concerned with the matters we've dealt with today, is there any reason why the trial timetable will not be met, and that any reason why we shouldn't proceed in September?
Not from our perspective, Your Honour. Particularly given the vacation of the expert evidence directions.
And we've got sorry, Sir Jackson, I shouldn't talk over you.
No, not at all. I was just going to say, actually, there is a fair amount of flex in the timetable now, given that the expert evidence has been dispensed with during stage one.
And we've got a pre-trial review, I think, in July, I think.
Yes, Your Honour.
Yeah. All right, well, thank you both. Thank you, the court staff. That completes today's hearing.
Thank you, Your Honour.